But thank you, everyone, and welcome. My name is Clint Grease of the Commoner Law Group. Tonight is our special presentation. What happens if you get arrested? What if you ever are arrested is a question that comes up in people's minds, sometimes in very concrete and real terms, but also just more in an abstract way. We researchers of the law and we people who live outside the box oftentimes wonder if the powers that be might not like what we're doing and might want to try to entrap us or somehow criminalize our behavior. And then we imagine in our mind that day when someone comes knocking at our door and they're wearing a badge and or armaments and they're using heavy techniques to intimidate you and maybe they actually arrest you. And that thought alone has put so many people into a presumptive state of fear and intimidation, such that sometimes people aren't willing to take risks that maybe they should do or they would otherwise like to do. I mean, let's be honest, nobody wants to spend a day or two or a week in jail just to prove a point, although that might be what might be required of us Americans eventually. Well, there's good news tonight because getting arrested doesn't have to be the end of the world. There are many things that you can do and should do if you are arrested. And our special presenter tonight, Todd Duell, has a very unique perspective on what you should do if ever you're arrested. And it has to do with the accounting that goes on in the background of our judicial system. And if you've been paying attention to our recent presentations, in particular, our most recent recording with Todd Duell is out on YouTube, and I recommend that everybody go out there and watch it. It's called The Secret Financials Underlying Our Justice System. And it's exactly those secrets underlying the justice system that allow you to handle those law enforcement officers who might come to you, try to intimidate, or even actually arrest you, take you to jail. So, thanks to everyone for being here. I'd like to introduce Todd Duell. He's an extraordinary person with an incredible background. Todd, we'd like to hear from you about the actual events in the last couple of weeks where you had the police come to your home and what the conversation was. We really want to try to get people experiencing it as if they were there with you, because again, that's for so many people such a frightening prospect. And so I wanted you to take your time and explain what happened, who said what did you say in return, so people can really almost live it vicariously through you. And then, of course, because of the principles that you're going to expose through your story, we'd like to take some time with those accounting principles that really underlie what goes on with the justice system, the truth of the matter. Unfortunately, it's not a question of justice as we so often like to believe, and how, when you are empowered with that knowledge, how it changes your demeanor and how it also has you be successful in the moment, that is during the arrest itself, and then what plans you have to hold these, I'm going to call them tyrants, accountable afterwards. So that's a tall order. And then we'll take some questions from you all. Todd, thanks for being our special guest. Thanks for being out front on this matter and being willing to come teach us a thing or two tonight.
Yeah, thank you so much. I'm grateful for you to have me on your podcast here and to, just bring these issues to light to everybody. So you understand that when you start asking the right questions, they run. Okay, that's the most important thing. They run. So what I wanted to do is kind of give everybody like the arrest and survival guide, right? Like, what are the types of questions you can ask these people to basically throw them back onto their heels, that you're onto their fraud of the securities that they're trying to open or have already opened against you.
You've got an actual document to share with us. Wonderful.
Oh, yes, of course. I always have documents for everybody to read and to, go through at their own pace, right? Because some of this is normal for me, but it might be overwhelming for a lot of people that don't know what they're actually doing to you or attempting to do to you. Because the reality is that if we look at it at a very basic level, right, which is called minimum contacts, what they're basically trying to say when they're interacting with you, we're talking about public, right? When the public is interacting you with all these color of law people, police officers, any government agencies, they believe that under some type of minimum contact rule, that you are attempting, or you believe, or you know that you are attempting to enter into a contract with them in commerce. That's what they think. They believe that if you're out in public, you're entering into a contract with them, and you knowingly and willfully are doing it, right? But the problem is they don't ever present you with whatever contract they opened, did they? Which what we're talking about is the security instrument. They opened it, they used your social security number, they did a 1099-A, they took a bunch of money for themselves, and then you're just like, I don't have a contract with you. Show it to me. I don't see anything signed. And then all of a sudden you find out, like in my particular case, yeah, they opened a security and didn't tell me they did that. When in my particular case, there was no court case, there was no warrant, no nothing, but they opened a security anyways to pay themselves to come to my house. Well, how is that a minimum contact? I'm a private citizen inside my house, and you open the security to walk through my door? What? I think I'm going to start filing some 1099-As against the sheriff's department, start walking in their doors and hope to God I don't get shot, right? By the police officer who has firearms, right? And has a right to shoot me when I'm inside their house illegally, right?
No, turn
This is
around to fair play in this
yeah,
case.
this is the stupidity of what these people are doing. So as a result of what happened, and I'll just kind of give a preview for it. Uh, I actually already have filed the 42 USC 1983 violation against the officers. I've also already, once I found the security a few days later, I filed the First Amendment complaint. So it went from a $8 million tort to a $400 million tort, right? And so so yeah, it jumped very quickly for the damage that they just did. They've harmed me. Not only so there's different types of harms. There's like the emotional harm, physical harm. So these are all harms. And now there's the financial harm. So now I've reserved my rights in both cases to go after them for the Fourth Amendment violation, the physical harm and injury. If you look at what the statutes say, or the law says about those types of injuries, and then you actually have a right to redress, right? Our government says if they broke the law, they were not operating even under color of law. Now you've got the 18 USC 1343, section A 1 through 4, that you might be able to charge against them in certain instances, because this is your right to redress them for grievances. They are not allowed to break the law. To them, the law, they believe, is statutory. They believe that they can write statutes and codes and ordinances against you, right? Well, the statutes, ordinances, and codes, those are regulatory infraction legislative jurisdiction. That means there has to be a contract somewhere. They create the contract for you with a bid performance and payment bond or some type of other security instrument. And then they file a 1099-A. They use your social security number to pull the credit from the Treasury Department to create this bogus security that they then immediately sell and transfer. So then they say, well, we don't have any bond. We don't have any security. What are you talking about? We've never heard of this before. And you're like, well, how come it's sitting on my IRS tax records then? That's aggravated identity theft of my tax records. You don't have an SSA 89 on file, me authorizing you to use my social security number like that. If you think that entity is yours, you can have it back. I don't want it. You know what I mean? And so what we're talking about here is they're accessing the money from the future labor interest deposit of your birth certificate banknote bond. Fine. If you guys want to get funded that way, you think I'm a walking ATM machine, you can have that thing back. I already discharged it anyway. So I'm a secured party creditor holder in due course. I have my estate conversion. That birth certificate was discharged back to the U.S. Treasury Department. So that means it's canceled. I want to know how you're accessing a canceled account. Why was this not canceled? Somebody is liable for you accessing a canceled minor account. So now you can kind of see the different level of power that you get with an estate conversion, where you start looking at these people saying, number one, I don't have a contract with you. Number two, I'm the trustee. You're not a trustee anymore. You're not a beneficiary named in the irrevocable trust that was created for the fictional estate. Where's the contract? Where's your power of attorney? Where's your power of trustee? How did you get legal title authority to do anything to this trust? Where'd you get it from? Did you just
That's a
step
great
in and
introduction,
take it?
Todd, to some of the topics that you're going to be covering tonight. But could we just start by humanizing it a bit and
Yes.
taking everybody to that moment? Describe it. Like the weather. What you were doing when the
Yeah.
doorbell rang, or just like really bring us to that moment in that story.
Yeah, so what I'll do is I'll just so I walk through it correctly and I won't say anything outside of what's already filed in the 42 SC 1983 complaint. I'll just kind of walk through it for everybody. So I apologize if I'm like reading it. This is a factual affidavit filed in the complaint, right? And so of course they can't rebut this because this is the truth, right? And I didn't leave anything out. I never leave anything out. Even if it's something that's against me, I will put it in there because that's the truth. I don't want to come back and bite me, right? And so what happened is on November 25th, around 10 o'clock in the morning, five armed Honolulu Police Department officers who were ununiformed deputies, they were like in their regular clothes. They basically walked through the front door of my house without my knowledge or consent, right? Just walked through the front door, right? I was actually in my room, and so they opened the door to my room without knocking or obtaining my consent either. So they're just basically like walking through my house, and it was really interesting because when they opened my door, I asked them to identify themselves by their name and badge number, and they refused. Okay, they refused. All right, well, now we got a problem. So I would ask the deputies to produce a signed warrant from a judge, and they refused. So I'm just like, whoa, well, you guys actually, if there's a warrant, you have to produce it, right? You can't just walk into somebody's house without a warrant. That's a huge Fourth Amendment violation. Now we know when there's no warrant and they just walk into your house. Now we know at that point that they are operating outside of color of law. They have no authority from a judge and a court. They have no warrant issued to do this. Now they're operating under their own accord, right? They are not going to be covered by a self-insurance policy at the risk management office. So everybody needs to understand, years ago, the police officers and the sheriffs had their own surety bonds, right? They got sued so frequently, they would never bond any of the police officers anymore. Okay, so then the departments carried like an umbrella policy for everybody. Well, then the department got sued all the time, right? And so they couldn't get insurance anymore either. And we're not talking just in Hawaii, we're talking generally across the nation. This is how it's rolled out. And this is confirmed by several of my colleagues that are either still sheriffs or retired sheriffs and things of that nature. So they're aware of this. And then what happens now is most of the counties go with what's called a self-insurance policy, which is managed by the risk management department. And you can always find this in the county annual financial report or whatever they may have changed the name to, because now that people are finding out the CAFR, now they're moving it somewhere else. It's like a shell game, right?
Mhm.
Where's the bond? Where's the insurance policy? Where is it? Oh God, we don't know, right? This is what they're doing. As soon as people figure out where the money's at, they start moving it and playing their little shell games. Okay. So now most of the time it's still, for most part, it's in the CAFA report, you'll see the self-insurance policy in there. So now we know that the police officers, they're not going to be covered by the self-insurance policy either because they didn't have color of law orders from a court to walk through a door, right? So now they're going to have to hire private counsel because the county council is not going to cover them, with the county council representing them. So now all of a sudden they're looking at very serious Fourth Amendment violation charges of kidnapping. They're looking at literally like criminal charges being filed against them by the district attorney, right? So now all of a sudden they're probably going to have to come up with, $50 or $100,000 retainer fees apiece to cover themselves because they're going to trial, right? So the next thing then, so no warrant. So the deputies basically told me, well, you're under arrest for probable cause. Okay. So I asked them, well, can you state the articular probable cause for the arrest? And they said no. It's like, fantastic. So no warrant, no probable cause, no court order. Okay, next question. I asked them, is there a pending criminal action filed in the state court? They refused to answer. Hmm. So what am I doing to these people? I'm investigating them because they're doing an administrative process to gather information they don't have. Remember, the entire system is administrative, and you're dealing with people that are third-party, non-firsthand witnesses trying to get information from you. So you always have to, like my dad would always say, and I tell my clients, invoke your Fifth Amendment right to remain silent, shut up again, and shut up some more. You don't answer questions, but you start asking questions. And they have to answer by law because they have a badge and they have an oath. So there's certain things They have to answer. And these are some of those things. Okay. So let's see, no charges in a state court, no case open. Okay. So basically what they did is they handcuffed me and they took me to the Wahiawa police station for booking, fingerprinting, and interrogation. Well, how am I being booked and fingerprinted and interrogated if there's no warrant, no court case, no probable cause of anything? They can't articulate anything that they're doing. Okay, so that's fine. So at that point, you can imagine I already got them on the run, right? So at this point, I'm just asking, anybody that will talk to me with a badge. I'm asking a bunch of questions because they're supposed to have their chest recorder on, right? So I'm pretty sure they didn't have it turned on because they knew what they were doing was illegal. So now they could get busted for not turning their recorders on if they didn't record, right? So now that's an internal police department policy violation because the counties and many counties are requiring them to have those on at all times in the event they do something dumb like this, right?
Did you ask, by the way, wow, in the moment, did you say, are your cameras on?
That's actually one thing I didn't ask them, but that's okay. I'll assume that they're supposed to have them on by policy, right? If they want to go off of policy, your policy said that recorder is supposed to be on. So if you come back to me during interrogatories and discovery and say the recorders aren't on, I'm going to go right to your chief and I'm going to say, oh, so they're running around without their recorders on while they're committing crimes? You allow this by your policy? I think these guys need to be fired for not following policy, right? So this is the type of things where police officers literally lose their career over doing dumb stuff like this, right? I didn't invoke them to do anything like this. I'm not out there, badgering them or causing any problems. My job is to actually investigate white collar crimes. Okay, that's my job. So if they don't quite understand that I'm actually, sort of working on their behalf and working on behalf of the federal government, well, they're going to learn a different lesson here today that you don't mess with federal informants. Okay. So then on the way to the Wahiawa police station, there's two deputies in the car. They've got an unmarked car. And so I asked them, hey, can you state the articular probable cause for the arrest? And they kind of laughed and they said, fuck around and find out. You're going to prison. You're going to lose your job. That was their response. Wow. So then I had to basically look at them and say, and I told them, you're not authorized to commit aggravated identity theft of my tax records for pecuniary gain in violation 18 U.S.C. 1028A, 26 U.S.C. 7201 through 7206, 671 through 677, SEC Rule 10b-5, 18 U.S.C. 472, 475, or you'll be violating 18 U.S.C. 153 for embezzling from my estate as an incidental beneficiary, committing defalcation. You can imagine a statement like that to a deputy or pair deputies who likely barely have a GED for an education, because they're all tatted up and they're speaking pidgin, just basically exposing to me how ignorant and incompetent they are and uneducated about what they're actually doing. And so their response was to basically scoff and say, federal law doesn't apply to us. Oh, really? Title 26 and Title 18 and Title 42 don't apply to you? All right. So remember, Title 26 is that's the IRS, and Title 18 is the enforcement penalties for violating the administrative law of the Internal Revenue Service, and Title 42 is for color of law. Okay, so they're always operating under color of law. Now they're trying to basically tell me that they can operate outside of color of law. Wow, fantastic. Do I get to do that as a citizen, private citizen? No, I'd go to jail. I'd go to jail if I did anything like that intentionally. Because remember, what they're doing is willful intentional, right? Because they showed up with 5 deputies, so they all got their little powwow together. And now the interesting thing is when you start looking at 19 USC or 18 USC, no, 42 USC 1984, 5, 6, and 8. What we're talking about is all of them got together. They knew what they were doing was illegal, and nobody stopped each other from doing anything illegal. So that's now a problem because they knew what they were doing is illegal, and all of them conspired together, and there's more than 2. So now they're in a lot of heat now. Okay, so
You're having this back and forth while you're in the patrol car in the back seat, like handcuffed?
Yeah, yeah. So I'm asking them questions because they're supposed to have their recorders on, right? So the story gets better, as you can imagine. So I reminded the deputies that, hey, you guys have a social security number, and the Honolulu Police Department has an IRS EIN number assigned to them. Therefore, you are in fact contracted with the IRS, and the administrative law of the Internal Revenue Service does apply to you at all times. That operating under color of law does not exempt you from tax evasion under 18 U.S.C. 371, 26 U.S.C. 7201 through 7206, 671 through 677 for willful embezzlement against the estate in violation 18 U.S.C. 153. So I just straight gave them the accounting codes they were violating, right? And so they scoffed again. Oh, federal law doesn't apply to us. Oh, okay. So now I get to tell the court that, I've asked these guys a couple of times about this. So the deputies are clearly willful tax evaders and willful non-tax filers that do not believe the administrative law of the IRS applies to them. The IRS, and then in my pleading is complaint says it appears the deputies claim they are above the law. That's what they're claiming. They're above the law. Somehow a badge and a gun makes them above the law. Wow, fantastic. I didn't know that you could be above the law for embezzlement and tax evasion. I didn't know that exists. I didn't know that the public officials could operate above the law under Title 42. I'm pretty sure that keeps you below the law. That's what it's there for, to prevent encroachment and overreach and abuse of our rights under the Constitution, at least the basic ones, because we all know in this particular space that we don't have constitutional rights in this country, right? Because of the Ashwander Doctrine. So it's Ashwander versus Tennessee Valley Authority, where because you've accepted benefits and privileges and continue to use your social security number to contract with the government, you've now reduced your rights to benefits and privileges, and so they've been stripped away from them. That's a very core concept that everybody has to understand in terms of why you operate with a trust, why you do your estate conversion. Stop using your social security number. And then you can look at them and say, how'd you use my social security number? I don't use that. I didn't contract with you. How'd you open a security using my social security number? How'd you do it? Who's doing it? Who has the authority? Where's your power of attorney to do it? Where's your power of trustee to do it? You don't have one, do you? It's a presumption that you could just use it. Well, I'm breaking your presumption now. Okay. So while I was at the police station, obviously there's two investigators. I always have a primary investigator and then another person that's a witness. Okay. And so the primary investigator attempted to read my Miranda rights. They're required to do that. And he actually literally told me that, and this is all being recorded, by the way, because now he's got the little recorder on the desk. So I'm just like, game on. I got you now, right? Because everything's being recorded for sure. And so he said he was there and he was required to protect my Sixth Amendment rights. And I was just like, oh my God, thank you for saying that. Okay, so this is one of those core things that everybody needs to know, and you need to read what the Sixth Amendment says on any criminal investigation. Okay, so he started to attempt his administrative process to gather information from me. So he's got his little form in front of him where he's just checking off information and stuff like that. So he's trying to get like your name and your address and stuff like that. But you have to remember, they already have all that. They have your driver's license. They already have it. Why do you even need to ask those questions? It's stupid, right? And so I basically, when he started going through, that stuff, I'm just like, well, I invoke my Fifth Amendment right to remain silent. Right? I'm smart. I'm not answering any of your questions. I don't have to. Right? So I refused to answer any questions, and I definitely refused to sign any of his documents, which made him really mad. Right? So literally on the forms that they have for you to that they're asking you questions, they literally have a section on there where they can check a box that says, witness refused to sign the form. Well, why are you signing for me? I told you I'm not signing your form. That's aggravated identity theft by signing my name saying that I refuse to sign the form. What are you doing? Right? You shouldn't have that line on there at all. You don't have the authority you don't have legal title authority to sign for me on any conditions. You're not the trustee for the estate. What are you doing? Right? And so I basically asked him a couple of questions, same thing again. So I asked the primary investigator, hey, is there a warrant for my arrest? And he said, no. Fantastic. You guys are in a lot of trouble. Right? Then I asked him, hey, is there an open criminal action filed against me? the primary investigator said no. Right, so no court case, no warrant. No, they're in a lot of trouble. It's getting worse. Then I asked them, hey, is there an IRS 1099-A open against me in accordance with IRS 1099-A and C instructions, page 3 and 4? Right, I'm getting really specific because I know who's opening these things. And he said, no. Okay. Then I asked him, hey, is there a QSIP for the 1099-A filed for the court case, trust securities? He said, no. Because remember, he doesn't have any of this stuff in his jacket there. He's basically got like one little piece of paper in there. For the most part, he has nothing. Right. So I asked him, hey, is there a bid performance and payment bond filed against me? He said, no. Right. So I'm getting really specific. I'm going after the accounting and the bonds. Right. And I could see him. He's just turning beet red. Right. Because he knows exactly what I'm after, and he knows I'm going after them for fraud. Right. He doesn't want to answer any of those kind of questions. But remember, he has to answer yes or no. He has to answer affirmatively. And so if he answers yes, well, you need to produce it. If he answers no, that's fraud and false statements and concealment. So it gets better, right? So I asked him, oh, okay, so under your oath, so I see that you have a badge, which means you have an oath. So I'll just accept your oath. And you just already admitted to me that you're here to protect my Sixth Amendment rights. I need you to tell me the Sixth Amendment nature of your accusation right now. That's the question they will never, ever answer to you because it exposes the commercial nature of what they're doing in the bonding and the underwriting system and exposes the accounting. Okay, so he refused to answer that question. Right? Just like the bar attorneys, just like the judges, just like the clerk of the court, the prosecutors, they will refuse till their grave to answer that question because they know they're caught red-handed. Okay, so I asked the primary investigator then if there was an injured party. He said no. Okay. Then I asked him, hey, can you articulate the cause of the accusation? So I'm still going after the Sixth Amendment, right? He said, no. So no nature, no cause. Wow. Wow. Okay. So then I dig a little deeper. I asked him, hey, by your oath, in accordance with Article 3, Section 2 of the United States Constitution, which of the two criminal law form jurisdiction are you operating under? Color law, colorable vice admiralty, or common law? He refused to answer. Mostly probably because he's incompetent. He was never trained with his criminal justice background in school, whether he has a bachelor's or master's in criminal justice, or whether he was trained by the police department or even the bar association. They're never going to explain to them the two criminal law form jurisdictions and the difference between the two. They want them operating under colorable vice admiralty, and they just tell them statutory. So statutory is colorable vice admiralty because statutory has to be bonded because the regulatory infraction legislative jurisdictional issues have to be bonded because they're going after you as a private citizen and hauling you into court into public. They're taking you out of private and hauling you into public. This understanding the basic core differences between private and public and how they get in res jurisdiction with the bond and then claim they have automatic in rem jurisdiction over you as the living man or living woman. Okay, that's how they do it. They'll never want to admit all the stuff from the law schools from Tulane Law University, Tulane Law School so that's the Tetleys, where they explain Benedict's on admiralty to the law students there and how they do in res and in rem jurisdiction to arrest and attach bonds to arrest people. Okay, and how they just do that all on their own. And the interesting thing is I was just speaking with a potential client, 50-year bar attorney, and he had a criminal case filed against him. And so we were talking to him a couple of weeks ago, and we were trying to explain this to him. And remember, this is a guy 50 years in the bar association, going into court, litigator. And he said that early in his career, when he was a public defender, he said he does recall in like the 70s and early 80s that they had to force their client to sign the bid performance and payment bond, or the judge wouldn't let them out of custody, wouldn't even issue them a recognizance bond or a bail bond. And he said, then after a while, he's just like, it just kind of disappeared. We didn't have to do that anymore because so many people refused to sign it. After 30 days, they had to let him go and dismiss the case for lack of jurisdiction. Right? So you see what they do. They just sign for you now so they get jurisdiction. right? But that's aggravated identity theft, isn't it? They're signing for you. You never authorized them to create these bonds. Okay. So at this point, I've done enough investigation for this guy, and I basically looked at him and I said, hey, in the event that you're making willfully fraudulent and false statements and concealing any IRS documents and forms and QSIPs and securities filed in res, okay, so that's the property against me in rem as the living man, that this is constituted as aggravated identity theft of my tax records for pecuniary gain in violation of 18 U.S.C. 1028A, accounting fraud in violation of 26 U.S.C. 7201 through 7205, fraud and false statements and concealment in violation of 26 U.S.C. 7206, and securities fraud in violation of SCC 10b5, 18 U.S.C. 472, 475. That I do not consent to your use of my tax records or the creation of any fraudulent securities, that any case trust securities that you have opened are to be immediately revoked and revested in accordance with 26 U.S.C. 671 through 677, and that your willful refusal will be considered extortion in violation of 18 U.S.C. 912 and embezzlement against my estate in violation of 18 U.S.C. 153. So I've got him on the record now, don't I? I've got him on the run, on his recording. I told him, like, I can actually subpoena this as discovery, and I can take you up on the stand, and I can perjure you on the stand over all of this. Okay, I will depose you on the stand, right? And so he turns his recorder off, and you can see he's just beat red. He's really upset. He slams his investigation folder shut, which had like one page in it, and he mumbled, "This is bullshit. There was no crime. This is a waste of my time." So now he just admitted there was no crime, right? He didn't put it on recording, but I documented my affidavit because that's what I heard him say as a firsthand witness, right? So I was released, shortly thereafter. They let me go pretty quickly. Um, and but the most part now is in the criminal complaint. Now I can, not criminal, civil complaint. The dumbest thing ever is these guys can actually commit crimes of kidnapping, and it's civil. The hell? If I kidnap anybody, I'm going to jail, and I know I'm going to jail, and I'm not getting out of it anytime soon. You can't discharge common law crimes. So they committed a common law crime by kidnapping.
Right.
Right. So this is why I think once the defender or defense counsel probably looks at that, they're probably going to look at him and say, we can't represent you. You need to get private counsel because this is actually a criminal act of kidnapping. Right. We're not authorized to cover you for that because the self-insurance policy doesn't cover you for what you did. All right. So yeah, so basically now the nice thing is then you can come in and now you've been threatened, harassed, psychologically and mentally harmed and injured by the deputies. And because there were no court orders, they were operating outside of statutory law, policies, procedures, and they weren't even operating under color of law. Right? You're unlawfully detained. That's Trezevant versus City of Tampa, which is $25,000 for every 23 minutes. And the interesting thing is I had one of my colleagues who's a judge actually review my complaint to the court. And he's just like, well, Trezevant, you can get 3 times as much of that, right? He's like, because that was a case in the late 80s. He's just like, so it's worth at least 3 times that now. Why don't you just put it down for like, instead of 192,000, I think it's like 560,000. I'm just like, because I'm not going to argue what the case says. I'm good with the 192,000 because I know they don't have it, right? And so this will basically be a burden upon these deputies for a very long time in terms of like wage garnishment and things of that nature. Yeah, I'm not going to argue against the case because if I say 3 times as much, now we have to argue with the jury, don't we? Right? We have to say, well, jury, this is 30 years later. Should it not be worth at least 3 times as much, or should I bring in a expert testimony from an economist that can actually do the increased value because of inflation? Right now, can I do it myself? Yes, because I have that kind of background with an MBA. It's not hard to show inflation and to justify it, but you'd have to bring in an expert witness to tell the jury, yeah, that's the right number to use. Because unfortunately, there's no other case at this point that's changed that value. Right. So I'm not going to argue it. I'll take the $25,000 for every 23 minutes because what I'm after is them to stop their nonsense and understand that they're going to get hit with really high penalties. Now, because it was kidnapping, Now, because of the psychological and mental harm and injury, so these are technical legal terms, I can ask for $1 million for that. I'm just going to throw $1 million down. That's what I think it's worth. The jury will determine if it's worth more or less than that. Okay. So now the interesting thing is a few days later, I had my broker check, right? And sure enough, what did they do? They opened a security instrument to pay themselves to come to my house. Oh, now we got a big problem, don't we? Okay, so now I have an affidavit in support of first amended complaint where I found the security, which now means that 28 USC 1343, section A through 1 for civil rights goes through for recovery for damages. Right now, I can do recovery for damages for any person who failed to prevent or aid in preventing the wrongs mentioned in 42 USC 1985. Now we just start rolling through the Title 42 violations that they committed. So, and that statute in the 1343, Section 3 is redress the deprivation under color of any state law, statute, ordinance, regulation, custom, or usage of any right, privilege, or immunity secured by the Constitution, providing for equal rights of citizens, right? So now you have the right to redress. They took money from me now, right? Not only they threaten and harass me and kidnap me, they took money from me too. Wow. So now what do I get to go after them for? All the things that I questioned them about where they said, no, 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 we're not doing that. We didn't do any of that. Well, guess what, guys? I found a security. Guess what, guys? I now put a UCC lien on that. That's now my property because you stole that from me. You didn't have any contract to do that. That's a fraudulent security. Now you are into securities fraud. Now you are into aggravated identity theft of my tax records. How'd you use my social to do any of that without my knowledge or consent? How'd you contract for me? You're not the trustee. You're not the beneficiary. You don't need, I have a UCC lien on the account that you took that money from, right? That's all mine. You have to pay it back now. Now we get to actually roll through basically the damages, like I said earlier. Now we're dealing with the criminal statutory provisions in the common law under the Internal Revenue Code manual, section 9.1.3. Accounting fraud, fraud and false statements, concealment, and then all the securities fraud stuff comes forward. So I've already filed all my tax documents. I've already alerted the IRS, the SEC, and a variety of other agencies that handle the criminal side for this. And because they don't want to give the accounting, right? They think you have to go to court to get the accounting. Well, I have the value of the pool that they're using at $380 million. Now we know where they're hiding the police officers are hiding their bonds. Now we know what pool it's in. Oh my gosh, and it's in a tax-free bond. How do they get tax-free bond for embezzlement? How is that tax-free? Wow, I would love to. And now, well, and here's the irony of all of this. If you really want to like sit back and laugh about it, you guys want to know where to do your investing? Do your investing in the police bonds because they can open them at will and commit as much fraud as they want, and they grow and grow and grow and grow and grow. Right? You're guaranteed going to get good returns out of those things. Just invest in the police bonds. Wherever they're invested, you invest. So wherever the criminals are investing, that's where you invest. Right. So I have to sometimes sit back and kind of laugh and just say, you can make a lot of money off these idiots just by following behind them, follow the money. Right. And so now because they don't want to give the accounting, because what did I do? I contacted the chief and I said, I need the accounting on that security. And you want to know what because I went like the next day, right, down to the main office, and they basically said, beat it. Right. We're not going to allow you to file any complaints. I'm just like, oh, so I can't even file with internal investigations or internal affairs? They said, beat it. It's like, wow, so you don't even follow your own policies for filing complaints for color of law violations. Oh, fantastic. I'll see you in court. Right? You want to play those games. So, until they provide the accounting, the best I can do is provide the value of their pool. Their whole pool is fraudulent as far as I'm concerned. They put a fraudulent security in there. The whole thing needs to come down, just like the 2008 mortgage crisis. Right, when they started to basically say that the value of the pools, it wasn't A rated, it was actually probably C rated, not even AAA, or like C rated, D rated. They lied about the value of the pool. So if their pool is like an A-rated pool, but how can it be an A-rated pool? They got fraudulent securities in there that nobody signed. What's going on with this stuff? The whole pool needs to come down. So, now it went from, now they've got actual real penalties because of all the IRS stuff they did. So notwithstanding the $380 million, I already had $8 million against them. Um, so now it's up to 402 million because of the value of the pool that they don't want to give the accounting on. So you can imagine that, even if they didn't give the full value of the pool, which is fine, the ledger, they can't lie against the ledger because that's the only information I have that will be disclosed. Okay, so at least it jumps from 8 million to, roughly, 30 million, right? Very quickly, because now they've got the more deputies they send, this is just a calculation. Why don't you just send 25 deputies, right? Every penalty that you commit is $250,000 per person that shows up. So I want all your names and badge numbers, right? So this isn't the first rodeo for me, as you can imagine, where I've literally had 20 deputies around me, and I start going off to the accounting and the bonds, and they all scatter. And I'm sitting there yelling at them, "Get your ass back here! I want your name and your badge number for the tort claim." Right? They run, right? Because they know that they're going to get lit up by internal investigations. They know they're going to get lit up in a 42 USC 1983 civil action. They're all going to get hauled into court. They're all going to be on desk duty. All kinds of nasty stuff comes down the pipeline for them, right? And that's all basically for just everybody understand what your basic rights are, right? They don't have a Fourth Amendment right to just walk into your house, right? There has to be a warrant produced. Now, the issue is once you get the warrant, when you look at it, you don't see the 1099-A, you don't see the bid performance and payment bond. You don't know if this thing's valid or not. So it has nothing to do with whether or not the judge signed it or wedding signature or anything like that, because they only have a photocopy of it. What you want to ask for is, oh, with this warrant, I don't see any of the IRS paperwork. I don't see the 1099-A, and I don't see the bond for it. This thing has to be bonded. I don't see the bond. This isn't valid, right? You guys are concealing information from me intentionally, thinking that somehow you have in rem jurisdiction over me because you took it with a bond. You guys are lying to me right now. Okay, so these are this is the kind of stuff that I put for everybody for the arrest and investigation survival guide. And I'm not saying that everybody has to be able to like spout stuff off like I'm spouting stuff off on there for everybody, but I want you to understand that even if you get a couple of these things right, ask about the Fourth, Sixth Amendment nature of their accusation, right? Ask for the 1099-A, ask for the bid performance and payment bond. So if you guys can do those basic things right and you can get them on some type of like chest recorder, or you can get to the investigator, don't answer any of their questions, invoke your Fifth Amendment right to remain silent. You start asking these questions, and if you even get to a trial, because remember, the prosecutor is going to hear this recording from the investigator at some point, and the prosecutor is going to be, oh my God, he asked all the questions that we refused to answer, and he's going to be able to put that investigator on the stand because I have to put the investigator on the stand, and he's going to depose this person. He's going to perjure him on the stand, and our entire case is going to fall apart. Right? These are your rights to ask these questions, to know what they're doing. Our forefathers that created the Constitution knew that they were creating a corporate-based Constitution to do commerce, right? And so they understood that the states at some point were going to abuse the Constitution, and they were going to abuse your rights to know the nature of what the government was actually doing. Because remember, when we did the independence, it was all about taxation. And so the government's back into taxing us to death and creating bonds and taxes all over the place. And they won't tell us what they're doing. They're concealing the accounting. They're concealing the securities, right? This is all an intentional process, right? And so we've got, maybe like if you were really advanced, there's like 20 things here that you could ask them, right? And so sometimes this just takes a little bit of practice, unfortunately, like having deputies around you and marshals and, being in a courtroom and stuff like that. And, they're doing all kinds of stuff wrong. And they don't even know, because remember, they're not trained by the Bar Association properly. They're not trained by their chief or their captains properly, because in many cases, they don't know this either. I've actually yet to talk to a single police officer or sheriff in many, many years that even had a clue what the Sixth Amendment said, that they have to tell us the nature of the accusation. They're really good at telling you the cause or the probable cause, right? But they have no idea what the nature is and they don't know how to answer that question. I'm just like, well, if you have a bachelor's or a master's in criminal justice and you've been trained by your officers and external, training, certified training people, why didn't they put the Sixth Amendment in front of you and you could actually read for yourself that there's two questions to answer or ask? They don't know. They don't know the answer to that question because you have to remember, no court is going to ever disclose, no administrative court is ever going to disclose the nature of the accusation because the entire system and the entire case falls apart as soon as they tell you that it's commercial, number one, under 27 CFR 72.11, and number two, they're not actually charging you necessarily as the living man or woman. They're charging your estate because that's the only thing that has credit, and then they're creating a bond for it, right? They're not going to expose what they're doing in any case, because as soon as that is exposed in any case, every single case in the country falls apart and everybody can use it. So now the next thing I do have in there as well as Clint that I see you're scrolling through there, which is, autographing like the bail bonds. Remember the bail bond is also, you're just paying a percentage of the full bail amount to fund the security instrument as an appearance bond. Okay. And so the remainder of the bond itself, whatever the value is, so if the court says it's $1 million bond and you have to give them, $100,000, $900,000 is taken from your minor account because what do you give your bail bondsman? Your social security number, right? Why would you have to give them your social security number? They always try to tell you, oh, so we can find you on your credit report and find out where you live, right? To verify all this information. No, I'm pretty sure the social security number is going to extend the $900,000 because you at the bail bond company are not putting up any money. So where did the extra 900 grand come from? Right? Where did it come from? Right? So you actually want to, at least autograph it with UCC 1-308 3-415. So that is without prejudice and without recourse. So you're not personally liable to pay or perform on the instrument. And the reason why you're not personally liable to pay or perform is because they didn't disclose the accounting and the securitization to you. So remember, like if you don't show up for your appearance, right, and they revoke your bail bond, right? And so if the court can't ever find you, they can basically take the $1 million from the bond. Well, okay, so you paid the court the $1 million because it came from the extension of your credit. They don't necessarily understand that, then they continue to try to arrest you wherever they can find you for a failure to appear because you signed a contract telling the court that you agreed to appear, right? Now, the interesting thing with that bail bond is that it's just an appearance bond, but for all intents and purposes, you could do equitable subrogation from that bail bond to do the set-off discharge, cancellation, and close all the accounts. But they definitely don't want to admit that, okay, that you can use it for that. Okay. And then, so at the end there, I basically say, hey, everything that you're doing basically is fraud, okay? The deception by misrepresentation of material facts, material damage because you have to rely on it, you have a right to rely on it. And, they basically commit fraud against you. They don't even know they're committing fraud, okay? And then ultimately, like we talked about at the beginning, which is this concept that they use in the administrative courts, which is the minimum contacts rule. Okay, so this is the doctrine referring to minimum due process, where they're basically saying, hey, you're trying to contract with us in some way. You're out in public. So clearly you're trying to contact us or contract with us because you're not sitting inside your house in your private space, right? Where they're technically not supposed to have jurisdiction. So you can see that that's what they're basically saying is you are taking purposeful and affirmative action to the effect of which is to cause some type of business activity foreseeable by you and the state. Really? How am I contracting with you? I don't want to contract with you. It's not foreseeable at all because you guys are concealing the contract you create for us with the securities, and then you turn around and use our social and you sell it, and then you won't give us any information about it. That means you're committing fraud at the state level with this whole nonsense minimum contacts thing that you're trying to use against the people that are in public. So hopefully everybody now understands there's a difference between private and different public. They're trying to basically extract you from your private citizen space to a public corporate fiction. They're doing it with these bogus securities and accessing your tax records and then not disclosing it to you. Basically, everything they're doing is fraud in the administrative courts to try to induce you to contract with them in public under statutory rules. Just don't contract with them. Stop contracting with them. Stop using your social all over the place. Know your basic rights. Okay. A mouthful for everybody. So I apologize, but I mean, you just have to see how this stuff rolls out, and that if they do anything dumb like this, you don't have to be scared. Okay, just know some of your basic rights. Go through that. Try to just remember some of these things. Just remember, if you get arrested, you're going to be under a lot of stress, right? A lot of emotional and stress and anxiety and stuff like that. You don't have to remember all 20 things like I can, or all the statutes and codes are violating like I can. But if you remember some of it's just the basic words even is enough, right? I'm revoking or revesting whatever trust you're making for me, right? Turn over this accounting and the securities, or this is embezzlement and fraud, right? These are enough things to scare the living bejeebers out of the prosecutor that now it's on a recording that you want the charging instrument, right? Where's the charging instrument? I don't see anything. I see no contract with you. I'm invoking my Fifth Amendment right to remain silent. I'm not stupid. I'm not entering in any type of minimum contact with you to enter any type of business arrangement with you for commerce. Go away. So that whole conversation that I had with the investigator at the Wahiawa police station, like 2 minutes. So I explained it to you in about 25 minutes, right? Because I added some, additional like color to it, no pun intended. But it was literally like 2 minutes.
So then he was all red-faced, as you said, and he finally just said,
Oh,
leave.
he slammed that folder shut so fast and turned his recorder off, didn't want to have anything to do with it. He bolted. He literally like I'm just like literally like looking at him. He ran out of the investigation room. Yeah, the law applies to them too. They have to, and so he, as soon as he told me that he was protecting my Sixth Amendment rights, I'm just like, game on, let's go. I know what you're violating. Right? That's what they do to every single person. They violate yours. They try to get you to contract with them to waive your Fourth Amendment rights, your Fifth Amendment rights, and waive your Sixth Amendment rights. This is what they're trying to do administratively, right? They think that they don't have to have a court case, they don't have to have a warrant, so they think they can just arrest you for just some type of minimal contact. So this is why when you're out in public and a police officer stops you, you ask them these types of questions. What's the Sixth Amendment nature of your accusation? Because they're gonna be like, oh, we have probable cause. Well, what's the Sixth Amendment nature of the accusation? Is there some type of minimum contact rule that I'm violating here? Am I trying to enter into any type of commercial contract with you in any way? Are you trying to open a bid performance and payment bond using my social security number by just simply interacting with me in some way, shape, or form? Because if you do, I'll see you with the IRS.
Good.
So instead of harassing them, right, and telling them to beat it, start asking some questions. First of all, I'm invoking my Fifth Amendment right to remain silent. Okay, fine, I'm in public. Here's my ID. I don't care. However, you're going to tell me the Sixth Amendment nature of your accusation right now and what type of minimum contact I'm entering into with you to create some type of contract to do business. You can't answer the Sixth Amendment nature of the accusation. You can't show me the contract. Beat it. Right? Rather than harassing them over, case law and this, that, and the other thing, just say, I don't see a contract with you. Beat it.
And so then I assume they chauffeured you home afterwards, right?
Yeah, I got a ride home. So I just had one of my friends come and pick me up. So,
Oh,
but
okay.
overall, it was like door to door, it was like 3 hours. So it's fine. I just wrote down 3 hours in the civil action.
Wow, what a story. Thank you so much. I hope
Yeah.
folks that as you're listening to the story, you see that getting arrested isn't the end of the world and that you have a leg to stand on as long as you understand the true nature of the accounting principles that they're using to, well, commit a fraud. And that
Yeah.
when you point that out, let them know that you know what's going on, they suddenly lose their their oomph. They lose their vigor.
Yeah. Well, I want everybody to understand that as soon as you tell them if they've created any security, so we're going right on top of the bullseye, like I'm going to give you a nuclear bomb on top of the bullseye. As soon as you believe that there's some type of case open, you say, okay, well, that means there has to be a bid performance and payment bond somewhere. That's a trust. I'm revoking and revesting it. And if you don't immediately revoke and revest it, you're embezzling from me, and that's a federal felony. And that's a prisonable offense for you. It's that simple. Where's the charging instrument? Where's the securities? If you're concealing that security instrument for me, which is a trust, I'm revoking and revesting it. You are now embezzling. I'll see you on the stand. I'm going to depose you on the stand. I'm going to perjure you.
Yeah, so maybe a little foreshadowing. What do you foresee happening with this lawsuit?
Well, I got them on both sides. Number one, I got them on the civil rights violation because they already admitted there was no case, there's no security or anything like that that was open. So they just walked through the door. That was illegal. So they get caught on that side. And then since I found that they actually did open security, now I got them on the U.S. tax court side. So either way, they're going down, right? And now they're not going to be able to not disclose the accounting on the U.S. tax court side because I immediately filed a keep cam criminal complaint too.
You think they're going to be motivated to settle with you, or are they going to
If
defend
they're if
themselves?
they're smart, they will. Unfortunately, the attorneys here in Hawaii don't know anything about bonding and underwriting, securities, or accounting. So they're going to play dumb and probably put in a 50-page motion to dismiss. And I'm basically going to have to respond back to them. You guys open the securities. So if you think you can also violate the Fourth Amendment and get it dismissed with your nonsense motion to dismiss, I'll see you in U.S. tax court, where now you're a named defendant in a criminal action. So if you want to play these games that you think you can violate the Fourth Amendment, I'm not going to appeal. I'm going right to U.S. tax court, and when I prosecute you, I'm going to have you arrested.
Amazing, amazing.
Yep. So if they're smart, they'll settle because I'm not here breaking any laws. I'm here to actually catch people committing, crimes, right? All the white collar crimes. That's my job.
Hmm.
Okay. So they don't seem to understand that I'm actually kind of working on their behalf in a certain way. And they should be bothering people like me. So I'm not running around breaking laws. We're busting people that are.
Well, that's the big question, I'm sure, is in everybody's mind. Why you? If they didn't have any charges, they didn't pretend to have any charges, and yet there they were
Well,
in full
they
force.
don't like it. They don't like it that they can see that they're being brought into U.S. tax court on a variety of issues with clients.
Who's that doesn't like that?
No, the government doesn't like that because that's what they're doing. They're doing tax evasion and embezzlement.
Hmm.
They don't like it that the IRS knows what they're doing, and the IRS has been tasked with basically rooting out the tax evasion and fraud. So
Yeah. Okay. Yeah, that's a big question. And folks, if you have questions, and Todd, you're willing to take a little time to go through some questions,
yeah,
yeah. So go ahead and type them to me in the chat, and we'll take them one at a time. So we've got some questions already. The first one's kind of long. Bear with me, but I'm gonna read it just as it was written. How do you make the distinction between you, either as agent or man, using their codes to hold them accountable? I ran into this issue during the COVID moment while enforcing my rights to decide whether or not I wanted to wear a mask. I didn't. The point is, if rules, codes, regulations, and statutes don't apply to me, and even though they do apply to them, how can I invoke them as a man? 18 USC 242, for example, and every other code refers to violations against persons. We are not persons as described, so how can I rely on those codes?
it's very simple because everything's a trust. The question to ask them is, from where did you obtain your legal title authority to manage my estate? Because remember, the government cannot interact with you because it's a fiction. It can only interact with your estate. And so, therefore, everybody's just trying to interact with that fiction. They're trying to get you to contract with them either by assent, meaning that you just voluntarily walk around, agreeing with their policies, or by contract, which is consent, right? So basically, you just understand that without a written contract, they're trying to get you to assent to comply. And you just say, I'm sorry, from where did you obtain your legal title authority to order my estate to do anything? Right? That is the question because we are dealing with the trust. Your estate is in a trust, right? Your legal fiction is in a trust that they allegedly control. So, hey, if you guys want that, then you can have it. But don't tell me what to do. I'm a living man or a living woman, and I'm not playing the sovereign citizen game. I'm here in trust capacity. So answer the question. If you guys think you have legal title authority to manage my estate, here's my birth certificate. Go ahead and put a mask on it.
Hmm.
Imagine you walking around with your birth certificate with a mask on it, right? Here we go. My estate has a mask, right? Don't tell me what to do, but my estate is all masked up to make sure it doesn't harm you, right? So if you want to get ridiculous with these people, you can. Or the best one is I actually one of my clients in the past heard me make this statement. So he sent me a Stretch Armstrong with like a picture of my face like taped or glued onto the face of Stretch Armstrong. Walk around with the Stretch Armstrong. Here you go. You can have this deader thing and throw it on the ground. But then it's yours. You can have it back. I don't want that thing. It's a fraud. All right. Put a mask on Stretch Armstrong. I don't know. You have to understand, though, that everybody that's in this particular space, you're well ahead of the curve of understanding the fraud of what they're doing and trying to make you believe that the legal fiction that they created for secure transactions is one and the same as you. They're trying to get you to contract your rights away under the Ashwander Doctrine to believe that you are the surety and the guarantor for whatever the fiction is doing. Right? It's just this nonsense game of what they're doing. And of course, remember, they're never going to admit this in a court case because the entire system would crumble, which is why I kind of point out to people in our legal circles, including attorneys and judges, if they would just decertify Erie Railroad versus Tompkins, they would have to separate out a common law injury crime from the statutory regulatory infraction legislative cases. Okay, those are all dischargeable under admiralty rules. And then your actual common law crimes would be its own separate criminal court, the way it's supposed to be, like in every other country. Right. So, like, for example, when you go to England, there's actually like 5 courts. There's a common law criminal court for people that are going to be going to jail or prison for injuring property or person. And then there's a court for law, a court for equity, a court for admiralty, and a court for maritime. You have to go through all of the courts and resolve the individual jurisdictional issues in those courts. It's not like in the United States where it's all blended together and they call it civil law. The attorneys here, like the example, the 50-year bar attorney that we were working with, didn't know that law, equity, admiralty, and maritime were joined together and called civil law. He didn't know. And he's been in the Bar Association for 50 years. He didn't realize it's the 4 law form jurisdictions. He only understands he understands law and equity, but he didn't know they were blended together, right? He didn't know about the bonds. He didn't know about a whole bunch of stuff, right? So it's really frustrating talking to a 50-year bar attorney that can't wrap his head around basic concepts of bonding, underwriting, and accounting. No clue. And it's not that he was incompetent, just no clue. He'd never been trained, right? Didn't know. And then all of a sudden he's having to back himself out of 50 years of conditioning very quickly.
I feel like I'm going through the same thing, and I've been studying the law, and now I need to study accounting principles.
Yeah. Yeah, the whole system's accounting. Remember, under the Commerce Clause, that's how the government is actually operating. They're regulating everything under the Commerce Clause. There's a really good case in the late 1990s. If you want to read about it, it's actually United States versus Lopez. And that's actually a case when you go, if you have a public defender, generally in some jurisdictions, and most actually, if you have a public defender or you go pro per, they want you to sign a waiver list. And there's a number of cases that they have you waive in there. And one of them is United States versus Lopez. And so if you waive that, now you don't have a right to a commercial remedy to do set off and discharge. Right? You waived your right. You voluntarily waived your rights, not knowing the case, because your public defender will be like, yeah, it's okay. You can sign this waiver. It's okay. Right? Well, that's shitty counsel telling you to waive rights. You don't ever waive your rights. If a bar attorney tells you to waive your rights, you look at him and you say, you're fired. I don't ever waive any rights. What are you thinking representing me, telling me that I have to waive my rights? Are you incompetent? You don't ever waive my rights. I will never instruct you to waive my rights. right? So isn't that interesting? There is a case that they're well aware of, which is United States versus Lopez, and that was actually a case where the Supreme Court basically said that, this is a case for firearms in a school district. They said that the government had the right to regulate the firearms use in and possession inside a school zone under the Commerce Clause. They straight admitted that the regulatory infraction stuff was under the Commerce Clause. Think about that for a minute. So I always have to remind my clients as well that your firearm, when you get your firearms license for an individual firearm that you purchase, what are they doing to get jurisdiction for that thing? They're creating a security and they're selling it because you signed an instrument with a dollar amount on it for the value of the firearm. You handed it back to your FFL dealer, and that goes over to the ATF, and they securitize it and sell it to get you to waive your Second Amendment rights to own your firearm. Right? So why do you think we pull those securities that you create, and we get the QSIP for it, and we file a lien against it, and we make sure that the box is checked as a national and not a U.S. citizen when you apply for that, and we throw the firearm into a complex irrevocable trust so you get your Second Amendment rights back. You need to read the statutes on the contracts you're signing on those forms, because it straight tells you with the ATF that if you sign as a national, you get Second Amendment rights. If you sign as a U.S. citizen, you get legal rights. You removed your Second Amendment rights away from them. And in fact, my sister, who's a bar attorney, actually is a nationally ranked shooter, right? And so she argued in the Supreme Court in California against the violations of the Second Amendment in California. And when I read a review, I'm just like, you didn't bring up the Ashwander doctrine that you waived your rights to, you have legal rights. And so, of course, her petition for all the people she was representing got shot down, didn't get certified. No certiorari. And it's like, as soon as you bar attorneys start bringing up the Ashwander doctrine and you revoke and revest and rescission your signature off all these fraudulent contracts that you signed to waive your rights, now this stuff will go through in the Supreme Court. But until you're willing to recognize what you're doing is waiving your rights for benefits and privileges, they're going to shoot you down every time. No pun intended. Right? But that's why it got shot down, because there was a contractor, she waived her rights. I show this to bar attorneys that are in the Second Amendment push, right, for our rights. And I'm just like, why did you check U.S. citizen and not U.S. national? And they're just like, I don't know. It's like, so you didn't read the contract you signed? They're like, no, apparently not. And then I've shown where the statute's at from the ATF, and they're like, oh my God, there's two different sets of rights. Yeah, you waived it voluntarily by signing a contract. And they put the statutes and codes in front of you, and you didn't read them. You just signed the form because you wanted the shiny object in your bag when you went out the door.
All right. Yeah, so this QSIP number, of course, is central to the whole thing. So someone asks about how we get the QSIP number, but maybe you could describe what central role it plays in this fraud scheme, when we need to obtain it, and how.
Yeah, let me pop one on the screen for you. So let's see, it's gonna be, I'll do the one for these guys. So that should be through. So the QSIP number is just a tracking number. Don't overcomplicate it. The pool amount in there is a pooled dollar amount. They're never going to give you the individual value of your security instrument. That has to be found out by the IRS through their own terminals for whatever the charge was against your ledger and your individual master account. So everyone's just like, oh my God, it's like $300 million. I'm just like, no, that's the pool. So we're just looking for the QSIP so we know what pool it's in, and that makes it easier for the IRS to audit. That's all it is, right? This isn't anything to use in any particular way other than to audit your IRS records.
Okay, and then how do you attain it?
So hopefully that makes sense to everybody, that you're not going to use this in the court case or anything like that. You're going to use it to audit.
Hmm. Okay. Is it very difficult to get a hold hold of that CUSIP number when you want it? There's multiple ones, right, for every instrument?
No, I mean, there's only supposed to be one for each instrument. We
Hmm.
are finding in some cases that they're doing it multiple times, which is that is actual fraud. Okay, that is actual securities fraud, selling the same instrument multiple times like that. So a lot of times, the brokers will only give you one, but if they keep searching, they might find multiples. So, for example, like my birth certificate banknote bond has been sold multiple times in its entirety. So that's always really interesting. I'm just like, okay, that's clearly fraud, but I'll take it because that's mine.
Okay, great. Another question, maybe you can answer it to some degree. It's a kind of a long story, I'm sure, but how does one revoke and revest the securities? Is
Yeah, you actually have to give them notice, right, to do it. They're going to ignore you. That switches from a civil issue to a willful criminal issue, and you take them into U.S. tax court for embezzlement. So this is part of the process that we have to do for like an administrative process for an audit, where we have to do a number of different things administratively. And then when they don't comply, as your trustees and your fiduciaries to do your accounting for you like they're supposed to, that's fraud and false statements and concealment. And now you have the right to audit and take them into U.S. tax court to reveal the accounting. So it is a process. It's not just like, just one little snap of the fingers and it's done.
hmm hmm
Right? Remember, are they going to admit they're doing accounting fraud, aggravated identity theft, tax evasion, securities fraud, embezzlement? Are they going to admit this to you in writing and respond to you? No, they're not going to. So you can't get frustrated because what you're doing is you're laying a trap for them that they can't get out of because you requested them as your trustee to do this stuff for you, and then they play dumb because they got caught. They know they got caught, and so as soon as they get caught, they go to their county council or their bar council, whoever it is, and their bar council says, "Don't respond, don't respond, don't say anything, because as soon as you say something, that's evidence. It can be used against you." All right. So that's actually fraud too, because once you call fraud, according to the IRS from as of September last year, as soon as you call fraud on your tax records and accounting, the bar attorneys were mandated by the IRS to audit their clients for fraud. So now the attorneys are in on it too, right? They were mandated, they were told by the IRS, right? So that's, let me see, I've got this, give me a second. Here we go. No problem. Here we go. Oh, you turned the chat, you disabled the chat.
Oh, okay. You're putting another document
Yeah.
in. Okay, yeah, good. Go ahead.
So this one's like 4 megabytes. But this is really interesting that the Bar Association gave this to the attorneys in the courts last year. Because remember, the Internal Revenue Service has been getting hammered by all the fraud that's going on all over the place. And so they are absolutely overwhelmed. They're like 2 to 3 years to even respond back to an initial fraud complaint. So basically, what they told the courts and the attorneys is, hey, here's your instructions, Attorney's Handbook of Accounting, Auditing, and Financial Reporting. And it basically says that if somebody calls fraud on your client, you have to bring in a CPA and you have to audit for fraud instead of concealing whatever your client is doing, because your client is clearly violating the Sarbanes-Oxley Act and the Securities and Exchange Act, which we've already ruled by Congress that you can't strike or deny, because then that's a willful criminal act by striking or denying Sarbanes-Oxley because of the Enron case, where both the Department of Justice and Enron were concealing their accounting. Everybody was concealing because everybody knew fraud was going on both sides. So that's when Congress stepped in with Sarbanes-Oxley after the Enron case and said, no more, no more concealing your accounting. You can't lie to us anymore. Right?
Very good.
So yeah, so it tells them, hey, if I call fraud, you have to investigate your client. You can't say no, they don't have to provide that. that you're committing fraud now too.
Wonderful. Well, this is a great document.
Yeah,
Awesome.
so now what I want everybody to see is when we're talking about the embezzlement, right? I want everybody to see who's liable. So I'm going to put this in for everybody as well. So everybody needs to see, I'm not talking case law, or anything like that, because it's all Sarbanes-Oxley, it's all, Securities and Exchange, it's all, generally accepted accounting principles and accounting for securities, right? They have to do the accounting. So if you look at, 18 USC 153, where, a person who knowingly and fraudulently embezzles or transfers any property or securities, because what are they doing? They're immediately transferring it. They're getting it off their books because it's a hot potato. Or if you destroy any documents that belong to you, because remember, your estate is the debtor, right? Your estate is the debtor. You're the creditor. So who's responsible? Oh, let's see. Any person that's participating in the administration of your estate as a trustee. Oh my God, that's the entire government. The custodian. Oh, the Chris custodian, right? The Chris custodian for the carts. The marshal. Oh, that would be a police officer. An attorney. Oh my God, the attorneys are liable, right? Or other officer of the court. Oh, the clerk of the court's liable. Or anybody else that they hire, an agent. Anybody that they hire to do any of this stuff is liable. And what does it say? Right? It says shall be fined. Shall, not may, shall be fined and imprisoned.
Hmm.
That's not may. That's not we think we might do this to you. This is shall. That's a very strong legal verb that should scare the living bejeebers out of anybody. That if somebody's committing fraud and I know about it and I don't do anything about it, I could go to jail with these people. My client should be going to jail right now. I have to turn my client in. Because if I don't turn my client in, I'm aiding and abetting. Right? I'm one of these people that's listed as a person that's embezzling. Says it really clear. Attorney, officer of the court. What are these people? Officers of the court. Right? What are police officers? Officers of the court.
Hmm.
Are they going to deny that they're not an officer of the court? They're going to deny that they're not a marshal? See how powerful that is? You revoke and revest. What are they when they don't give you the accounting and they don't do the recoupment? Because remember, revoke means you're canceling the trust. Revest means you're liquidating it. And if they don't revoke the trust and they don't liquidate it for recoupment, that's embezzlement. And it's willful gross accounting misconduct and willful embezzlement. So under Internal Revenue Code 9.1.3.
Criminal statutory provisions and common law with the IRS.
Oh, yes. What are they violating? Accounting fraud, 26 USC 7201, right? The IRS marches right through it. So you see that, right? Criminal statutory provisions and common law. So what does common law mean, everybody? Okay, that means that this applies to everybody. Okay, not only this has been laid down under public law by Congress, the Supreme Court backs this, the IRS backs this, the courts are supposed to back this, right? So common law means it applies to everybody because it's been determined that this is under public law. So statutes at large applies to everybody. You can't say no, but they try to say no all the time. Never heard of this before. Well, ignorance of the law is not an excuse. So now all of a sudden we're talking accounting fraud, 7201, right? Now we're talking 7202 violation, duty to collect and pay taxes because they're embezzling. They don't think they have to pay taxes. Willful failure to file a return or supply information. They won't give you any information, right? You filed the A and the C against them and gave it to them. They don't file because you basically told the IRS that if they file, they should be audited for fraud. So they're not going to file. So now they're busted for that, right? You've got 7204 fraudulent statement or failure to make statements, right? So the statements they are filing with the IRS are fraudulent because they didn't report the A and the C that they got, right? Fraudulent withholding exemption. They think they're exempt from filing taxes after they embezzled. That's not true. And then 7206, fraud and false statements and concealment. This is the core of this criminal statute provision from the Internal Revenue Service. You are not allowed to do accounting fraud. So hopefully everybody understands that concept of everything they're doing for you is in a trust. As soon as you revoke it under 26 USC 671 through 677, you revest it, right? Now they have to cancel the trust. The trust is a security instrument. They have to liquidate it. They have to do recoupment. When they don't, that's embezzlement. Now they have to file all their taxes with the IRS and pay taxes. Well, if these people are running on a shoestring budget and all of a sudden they're looking at 27.5% on a $380 million fund, you think they have that? You think they have $100 million to pay taxes? No, they don't have it. Right? Because the entire fund comes down for tax evasion. Why do you think they're scared? Somebody has to go to jail for that. Actually, I should say somebody has to go to prison for that. So you see how serious of a nature this is and how far out of control it can get very quickly because they're committing so many crimes, it's unreal. There's no case law in their favor for them to do this. But I tell you what, I have the 1,200-page training manual from the IRS for this 9.1.3 that they use for the Department of Justice, tax department prosecutors that they use against people breaking these laws. And who does it state that they busted before? Judges, bar attorneys, all kinds of people have been busted. They use the case law that's already been established in the courts under the common law to go after these people that are committing tax evasion. Okay, which is really interesting because that kind of brings me full circle to when I was a young teenager and my dad, as a bar attorney, had to beat the IRS twice, right? Because they basically said that that the money that his clients were giving to him was income. And then when he transferred it to his personal income bank account, it was double income, right? And he's just like, no, those trust accounts are for my clients. That's not income until I put it into my personal bank account. That's income. And the IRS couldn't wrap their brain around this. They thought there was some type of like double income going on. And so he beat him on these issues twice, but they used all of these statutes and codes against him from the IRS, but he beat him on the accounting because they couldn't certify the accounting, and he actually proved that they were committing fraud by not understanding the general ledger. Right? So you got people at the IRS that don't know accounting either, which is sad, but that is true.
All right, just a couple more questions, and then we'll have to say goodbye. One of these questions kind of comes up in different forms a lot. People are afraid that the court's just going to railroad you when you're representing yourself. You're using these legal theories that maybe they're not familiar with, whether they're ignorant of them or they want to pretend to be ignorant of them. They might hold you in contempt of court, that kind of thing. Can you speak to that?
Yeah, when you appear in court, so this is why I have that document, how to appear in court.
Hmm.
And so you need to basically appear in court specially and not generally. And so when you're under general jurisdiction, you're under their statutes and codes and policies and procedures for the courts. When you appear specially, you are there for one thing and one thing only, the accounting. If you argue statutes and codes or anything like that, you're back in the statutory jurisdiction and you lose. Because they don't want pro per people in the courtroom beating bar attorneys. Because you're basically in there for the accounting saying, hey, I don't think you have standing because you can't produce the accounting. Remember, standing is a huge issue in the courtroom. If the other party doesn't have standing, the case unravels. Okay, but standing is a presumption until it's proven. So it's a thing that you can challenge for jurisdiction. As soon as you start, throwing case law at them and all kinds of stuff, they're going to shoot you down because they're administrative courts and they don't have to follow case law because they don't have to accept common law. But they will force you to follow their policies and procedures. But you do have the right, every single person, even attorneys have the right to challenge jurisdiction on virtually any issue. Actually, any issue is a jurisdictional issue. And as soon as you raise it, it has to be addressed. The court can't continue until the jurisdictional challenge is resolved. Now, yes, you are absolutely right. As soon as you go after the accounting in the courtroom, they're going to say nonsensical. This doesn't make any sense. We don't understand. Jurisdiction challenge denied. Okay, fine. I'm revoking and revesting the trust for the court case trust securities. I'll see you all in the U.S. tax court where you can't gaslight the accounting. Right. So sometimes you have to just, play their game and just say, fine, I'm revoking and revesting the court case bond for this civil case. And so now both of you are embezzling. So now you as the judge and, all the court officers, the clerk of the court, you're all embezzling now. You won't do the accounting. You won't give me remedy for accounting in a state or federal court. So let's go into Title 26. Let's go to U.S. tax court where the only thing we can talk about is the accounting. Right? So automatic move. There's no appeals because what they want you to do is appeal a bunch of times while they laugh and they just keep opening more bonds against you and deny all your appeals. We've seen this happen all the way to the Supreme Court where people are arguing the accounting all the way to the United States Supreme Court getting shot down even in the United States Supreme Court over accounting issues. Go to U.S. tax court. That's the right jurisdiction. Now the only thing that applies is accounting in Title 26. Who violated what?
Good.
Yeah, so that's part of knowing how to appear in court. When you appear specially, right?
Mm.
Don't let them steamroll you. Don't say, we're going to hold you in contempt because there's no appearance. Well, Your Honor, I'm sorry. You can do whatever you want, but I'm appearing specially and you can't hold me in contempt. You don't have jurisdiction. Right? They've tried to do that to me too. And basically I saw the judge just kind of like huff, and then he stopped his little nonsense game of trying to hold me in contempt. Sorry, you can't hold me in contempt. I'm here for the accounting. And I actually told him, you're in contempt right now for not forcing the accounting forward. He didn't like that, but too bad, so sad. I'm not going to put up with their nonsense. Right now, a bar attorney is not going to say something like that to a judge, right? Because, they're going to get hauled in, to chambers and all kinds of other stuff and say, hey, don't you dare ever, make a fool of me in my own courtroom ever again, right? Or I'll rule against you for the rest of your career. Right? They do that kind of stuff to the bar attorneys, right? Do as you're told or we'll never rule in your favor. Like your career's over. Nobody will hire you because they know you can't win anything.
All right. So, folks, I see a good number of questions still coming about the QSIP number, and I'm starting to think that maybe we need to do a whole dedicated session on that if you're open to that or not.
Well,
Um,
in short, everybody just look up QSIP from Investopedia. They have a pretty good explanation of what that is. It's just a tracking number. Don't overthink it. Right? They have to track it in their database, the security, some way, somehow to know who has it and how much money it's made. That's it. It's a tracking number.
okay.
Okay. The QSIP itself does not deter the courts from moving forward. It does not absolutely stop a court case. The interesting thing is in the past, if you gave the judge a Form 56, and this was like 10, 15 years ago, gave the judge a Form 56, they'd run. But now they know or they believe the IRS isn't coming, so now you give them the QSIP, they just laugh and they gaslight it, right? Now you file, U.S. tax court cases against them. They just laugh and they think, oh, well, the IRS isn't coming and we still have jurisdiction. Um, and it's just like, well, you can't hear or try this case. I filed a key town criminal complaint against you. And so you're a named defendant. So you have to recuse yourself. And now they're saying, nah, we still have jurisdiction. And so they're basically at that point, they're saying, we're going to railroad you in this court. We don't care if we have criminal charges filed against us. Right? This is how narcissistic they are that accounting doesn't apply. But at the end of every case, I don't care if it's civil or criminal, the judge always has the accounting and says, you pay, you perform. But when we ask for the accounting up front, they gaslight you the whole time. It's stupid, right? Absolute insanity.
Well, that reminds me, do you want to share with folks your potential role in a larger solution for Americans?
Uh, Maybe not at this point.
Okay.
There's some big stuff coming in the next 1 to 2 months.
Todd's Todd's being tapped. That's all I'm gonna say. Todd has got big. He's a resource for not just the folks here tonight. Let's put it that way. Thank God. We wish you so much success,
Yeah.
Todd, in
We
what
just
you.
want the accounting. We don't want everybody to stop lying. It's simple. Right? I'm not overcomplicating anything.
Yeah, so we wish you the best of luck in that realm, and we thank you for being with us tonight and sharing your wisdom. And again, I hope folks aren't any longer as afraid of being arrested if that should happen for whatever reason. If you
Yeah,
find yourself in the situation where there's some guys with badges and guns coming to intimidate you or take you away, you can start talking the accounting language and send them packing.
yeah. And it's also fun too, Clint. Everybody should recognize that you can actually now sign up to be a private auditor for the IRS. So I do encourage everybody, if you're having trouble in this particular space, there is a program now where you can assist the IRS as a private auditor. You don't have to be a CPA, you don't have to be an attorney or any of these types of things. They'll literally let you sign up and be a private auditor. Right?
Wow.
You're basically an informant now for the IRS.
Wow, that really does change the normal
Yeah,
adversarial attitude towards the
yeah.
IRS that most people
You
have.
you can imagine having that document in your car saying, "I'm an IRS auditor. Here you go, Mr. Highway Patrol. I'm going to audit you for the securities fraud you're about to open. Thank you
Yeah.
for signing that with your badge number. I know who you are now."
And that's on the IRS side, is that right?
Yeah. Doge has been very busy with the IRS saying you are going to audit. And the IRS is saying, we need help. We're overwhelmed. We're 3 years behind on all the fraud that's going down. And they say, fine, let people sign up and help you. And we're not talking TAS. We're not talking the taxpayer assistance service people. They're worthless. They can't actually do anything except give you forms. But if you want the form to sign up as an IRS auditor, you can get that from TAS or you can get it from the IRS's website.
Again, thank you for being here, Todd, and sharing all of your wisdom and your personal life experience and how you have a superpower, and we all need to share that same superpower. Hopefully, we'll have it when we need it.
Yeah. So don't be afraid of the IRS anymore either. They're your friends. Go be an auditor for the IRS.
Yes. We'll get the IRS working for the people one day, which means they'll basically put themselves out of a job, maybe. I don't know how that's going to work.
Yeah. Maybe we can help them clean up the mess a little faster.
Yeah. Well, thanks for your integrity and thanks for your commitment to ironing out the wrinkles in our corrupt, fraudulent system and training people, teaching people what they need to know to empower themselves. This
Yeah,
is going to be
be peaceful. Don't harass the people in public. Don't harass the public officials and stuff like that. Just sit back and know that they're the ones actually committing fraud. And you can kind of laugh at them, knowing that there's actually remedy against them if they want to continue doing what they're doing.
Amen. Okay, everyone. So that's it for Commoner Law Group special presentation of whatever would happen if you were arrested. And thank you everyone for showing up. Look for an email in your inbox announcing the videos available on YouTube, or you can just go ahead and subscribe to our YouTube channel and set notifications so that you get alerted immediately when the video gets published. Thanks again for everyone being here. It's a wonderful, wonderful time together. And I wish you Merry Christmas and a Happy New Year.
All right, thanks, Clint. I'm very grateful for your guys' platform and to help everybody understand what their rights are.